This is Michael Popok. It's after dark. Do you know where your legal AF is? I know where it is, in D.C. with Judge Chutkan. What is Judge Chutkan doing? Who did she side with? Did she side with the special counsel's office about a fast briefing schedule on the brand new superseding indictment against Donald Trump issued by a brand new grand jury and to get that case to trial? Or did she side with Donald Trump? Is she going to go fast or slow? When is the immunity decision going to be back up on appeal to the United States Supreme Court? Is that going to happen before the election or even before the inauguration? And what's going to finally happen with Donald Trump trying to get rid of, the special counsel, arguing that he was illegitimate and improperly appointed under the Constitution? What's Judge Chutkan going to do all about that? Well, if you want to know, tune into Legal AF because we covered it all. Here you go.
Michael Popok, a big hearing in the Washington, D.C. federal criminal case against Donald Trump, a superseding indictment, was recently unsealed. Special counsel Jack Smith impaneled a grand jury in secret that re-indicted Donald Trump with some slight tweaks in how the indictment was pled, some different language, if you will, to conform to the Supreme Court's ruling on absolute presidential immunity. I mean, look, Donald Trump appointed 3 right-wing Supreme Court justices who teamed up with the other far right-wing Supreme Court justices, and they've made a lot of chaotic rulings. And you can argue which one is the worst of the rulings this 6 supermajority Supreme Court justices have done, but arguably this is the most egregious, saying that there are kings and monarchs and people are above the law if you can say there's core constitutional functions or official acts. And they even gave Donald Trump an evidentiary immunity as well when Trump wasn't even asking for that you can't even introduce these things into evidence. So special counsel Jack Smith, it impacted that case, right? It impacted the New York case that we talked about earlier as well, since the Supreme Court came up with this evidentiary immunity concept. And so if you introduce evidence of things that happen while Trump is in the White House, can that require a new trial in New York? Is that harmless error or is that reversible error? That's the issues that are before Justice Merchan in New York. And here in Washington, D.C., the issues are more along the lines of Jack Smith having to frame this indictment in terms of Donald Trump is a citizen, he's a candidate. And he did this not in his official capacity, but in a unofficial, non-presidential capacity to try to overthrow the results of a free and fair election. So Jack Smith knows that Donald Trump's going to bring this motion to dismiss again. Everybody knows that following the Supreme Court's ruling and based on how this superseding indictment is pled. So Jack Smith wants to be very efficient about it. So Jack Smith was saying to Judge Chutkan, here's an expedited briefing schedule that we should follow. Donald Trump was saying, yeah, let's not expedite this. Maybe we deal with whether there is a legitimacy behind the special counsel. Like Judge Cannon made the ruling that special counsels are unconstitutional only as they relate to Donald Trump. They're apparently constitutional when they're prosecuting Hunter Biden, because that's fine. But when they're against Trump, special counsels are eliminated. So Judge Chutkan, can you maybe look at that first? And then maybe later we'll get to the absolute immunity issue, which I think we talked about in the last Legal AF. You could obviously tell what gamesmanship that is, because if you truly thought you had immunity, wouldn't you want immunity to be addressed right away? Would you want to, if you were accused of something and you believed you're immune, would you want to be like, yeah, let's save immunity for 2025. Let's deal with some other issues first. That's kind of what Donald Trump was arguing. So the parties went before Judge Tanya Chutkan. It was like the first time they were before Judge Tanya Chutkan. Jack Smith's team, Tom Windham on behalf of the DOJ, John Lauro and others for Donald Trump. First time they were in front of Judge Tanya Chutkan in about, since December of 2023, when there was a hearing on Trump's motion that she denied before it went through the Supreme Court and all of these delays took place. So Popok, why don't I hand it to you? Tell us what went down at this hearing and what was the order by Judge Tanya Chutkan, and what's the import of that in terms of the filings?
Yeah, we waited 8 months for this hearing. A lot of orders in between getting us here. The judge was working overtime last month to kind of issue, once the case got returned to her by the United States Supreme Court in a mandate. She had some work to do. She did some chopping some wood beforehand and denied some motions, set some briefing schedules. We know that Jack Smith asked for 3-week extension to turn in his term paper. And the judge says, all right, there seems to be no objection to that. We'll give you the 3 weeks. And then Jack Smith went out and went to a sitting grand jury and got a superseding indictment in the interim to defend the superseding indictment against the immunity decision by the Supreme Court, not his original indictment. And this hearing did not go well for Donald Trump, not just because Judge Chutkan basically adopted, as you and I predicted, and I predicted on a hot take, virtually the entire schedule and scheduling process logistically, but that was proposed by the special counsel through Tom Windham, was adopted by the judge, including letting the prosecutor go first to defend the indictment against the immunity decision, which is a little bit unorthodox. Usually a motion to dismiss goes first by the defense, and it gives an extra brief to the prosecution, but she went that direction. Donald Trump said before the hearing, why don't we schedule all this out so it's in late 2025, like beyond even the inauguration? Maybe we never get to it. And the judge was like, no, we're going to go with the briefing schedule ultimately that the prosecutors proposed. And the reason is, and I wrote a note on this, she didn't quite say it this way, but this is the imagery I had in my head. She wants at high velocity to get to that brick wall at the end of the road. What I mean by that is she admitted, as we all knew, that the loser of any of her rulings about immunity are the person that comes in second, Trump or the prosecutors, are going to take an appeal. And the quicker we get the trial court decision-making done, appropriately, but expeditiously and quickly, the quicker the party can take the DC Court of Appeals appeal, which we know takes, a month or 2 months or 3 months, depending upon what's going on in their lives, and then up to the United States Supreme Court to see if she did it right. So rather than stretch out all of her proceedings so that the inevitable, as she admitted, the inevitable immunity decision we're all hurtling towards gets made like in the 2026, let me get my work done here with the lawyers here quickly. So she set all these dates that we talked about earlier. She wants the first brief to be the prosecutor's brief, which is a bad look for Donald Trump, as the prosecutor has said in the brief, which means filed on the public docket, which means you, me, Karen, and the rest of the network get our hot little hands on it on the 26th of September, in which they're going to put up new evidence they're going to air new evidence that we've never seen before. And Donald Trump hasn't seen before. I mean, it's somewhere buried in the discovery he's been given, but he doesn't know how it was going to be used, and all in an effort by the prosecutors to defend their superseding new indictment from a new grand jury against the immunity decision, arguing that none of the facts, none of the evidence that they plan on using at the trial falls into any of the immunity buckets. And if they do, that they'll be able to rebut the presumption of immunity, or it's not immune from prosecution. The evidence or the acts, anything that's listed in the new superseding indictments. First brief is the 26th of September. Actually, the first issue will be on the 19th of September, when Donald Trump has to finish up his arguments about why he's entitled to more discovery, more data and documents and information and witness statements from the special prosecutor. She wants him to conclude his discovery motion practice on the 19th. Again, this is Judge Chutkan effectively adopting the prosecutor's position that all of these issues should be done simultaneously, so that when she makes the immunity decision, wink, wink, nod, nod, against Donald Trump, and the superseding indictment survives, that may go off on appeal, but everything else is sort of done in the case and can go up on an omnibus appeal almost at the same time, rather than sequentially, which is what Donald Trump wanted, right? Rather than concurrently, he wanted it sequentially. Like, well, let's do immunity first, and then we're going to file the motion to say that if it survives that, then we'll turn to Jack Smith being illegitimate, and then we'll file our motions to dismiss, and we'll do all that seriatim, and we'll be in 2026 by the time that's over. Judge says, no, you're all taking appeals. Let me get my work done quickly. I'll adopt their schedule. That sounds like a good idea. That immunity briefing by the government is your and my We refer to it sometimes internally as prime rib, prime roast. We can't wait to get our hands. I'm going to put my napkin around my neck and a knife and fork, and so are you. We're going to dive into that. There's going to be a whole bunch of new stuff, some of which we may have sensed from the Jan 6th report that was issued, but some of it we probably have never heard of before in our lives, and we'll hear about it for the first time, which means the electorate and the voting public on the 26th of September, while voting registration and early voting is both still going on, will be out in the ether, out in the water supply for voters. Really, really important. It's not the mini trial that I never thought they were going to do, but they feel they got to defend their evidence against the aspect of the immunity decision of the Supreme Court that goes towards evidence. Then we've got the two. That's one golden nugget, as I talked about it in a hot take. The second one is this back and forth, this cat and mouse between John Lauro, and I can't for the life of me know why they brought him out of mothballs to argue here. John Lauro is a Florida criminal defense lawyer. At best, I thought I would have seen him in the Mar-a-Lago case. But I guess since the Mar-a-Lago case has gotten dismissed and is on appeal, there was nothing for him to do. And maybe they thought, people like Todd Blanche and Emile Beauvais are sort of tied up in some other issues with sentencing, and they wanted to try a new voice in front of Judge Chutkan. So they brought out John Lauro, not to be confused with John Sarro, who's a wholly different appellate lawyer that we talked about at the top of today's podcast, arguing as an appellate lawyer for Donald Trump in New York. Lauro comes out, and I don't know if he's rusty or he just hasn't advocated for Donald Trump recently, but he said some really stupid shit out loud. That's a term of art we talk about on patreon.com or Patreon, Legal AF and Patreon. For instance, when he said, well, Judge, we're going to file a motion to disqualify and find illegitimate the prosecutor under the Appointments Clause of the U.S. Constitution, just like Judge Cannon's ruling that just came out. And there the judge kind of sat back. This is people that were in the courtroom, kind of sat back with their hands folded and said a version of, I didn't find Judge Cannon's ruling particularly persuasive. And I think it is against the weight of precedent in my bosses at the D.C. Court of Appeals, the United States Supreme Court. That's that hierarchical jurisprudence or stare decisis that the Department of Justice has complained that Judge Cannon ignored, which means in simple terms, she's ignored the rulings of her bosses in making her decision. They work within a hierarchy of appellate courts above them, which of course Cannon ignored. So the Cannon motion, what I call it, she basically laughed out of court. He can file it, but you already see he's running, he's climbing Mount Everest without oxygen with Judge Cannon, to which he decided he needed to double down on it and reinforce it and show that it had some credibility by saying, well, Justice Thomas invited us to file that motion. She said, excuse me? Justice Thomas invited you? Well, what he's referring to is in his concurrence, and for no other reason, because he didn't have to write a concurrence. In his 2-page concurrence, he set the table for Judge Cannon, basically improperly. He did two things improperly. He communicated to the parties where he stood on a certain issue that could be in front of him in the future, which is a violation of his ethical duties as a judge. You're not supposed to signal to parties who may have a matter in front of you in the future about what your position is before you've rendered your position. But instead, he laid out the strategy. He said, file the motion. I think the issue of the legitimacy of the appointment of the special prosecutor is one that should be addressed because he's a stranger to the case. And why is he even prosecuting this case? And how is he funded? Nobody else on that Supreme Court, even Alito, even Gorsuch, who regularly sides with Clarence Thomas, even they were like staring at their shoelaces like, we're not siding with him on that one. And what did they do? That was the signal. You and I talked about it in Hot Takes as improper messaging by Clarence Thomas to both Donald Trump and to Judge Cannon, who sat down at the table that was set by Justice Thomas, put on her little napkin and knife and fork and had a meal and decided that was a great idea and found for the first time in federal jurisprudential history that a special prosecutor, special counsel, whatever you want to call it, is an invalid exercise of inferior office appointment by the Department of Justice head, the Attorney General, even against the weight of United States Supreme Court precedent from 1974 in a case involving Richard Nixon. So she said, "You're telling me that Thomas communicated with you?" Well, that's a figure of speech. What I meant is it was an invitation that we accepted. Right. That is exactly what should not have happened. And it is a signal by Justice Thomas before he gets the case in front of him about where he stands. That's a cardinal sin of judges, and it's yet another in a heaping pile of ethical violations by Justice Thomas that have happened. The end result of this hearing, terrible for Donald Trump. Evidence that wasn't known to the American public and the voting public is going to be made public on the 26th of September. Donald Trump's going to probably lose some motions along the way with Judge Chutkan at the rate he's going. There's going to be another brief by the feds on the 17th of October with more evidence after they see Donald Trump's brief. So 2 bites at the apple by the prosecutors because Chutkan allowed them to go first. That's terrible. She adopted their expedited briefing schedule. Terrible, but great for the American people and the American electorate, because I've always said, I don't care which side of the aisle you're on. I don't care about red versus blue. I care about red, white, and blue. And the American people should know before they go behind that curtain, electronic or otherwise, and pull that lever, who and what they are voting for. Data and knowledge is power. And the more knowledge they have coming out of the criminal justice system and the civil justice system that we just spent an hour and 10 minutes talking about, the better for the American people. And let them decide. And I put my faith and trust in the American people to make the right decision, especially now that the other choice is the only choice, which is the one party who's the protectorate of the rule of law in our constitutional republic.
You know, in the court system, it's all about data, admissible data, referred to as evidence. And when juries, going back to your point, Michael Popok, have heard the evidence against Donald Trump in the environment, the sterile environment, if you will, of the court where all of the propaganda is removed, right? Our legal system is about admissible evidence. Not the crap, not the lies, not the hearsay, not the propaganda. Boom, give me the facts before the jury. Unanimous jury after unanimous jury. If you factor in the grand juries that have indicted, in addition to the juries that have convicted, you know, when you have polls, right? I mean, they take samples of 100, 300, 1,000, 2,000, 10,000 people. But just imagine a poll where quite literally hundreds of citizens now, if you factor in the grand juries, the special, you know, the juries have come together and essentially have unanimously found that Donald Trump is a criminal, or that Donald Trump is liable for sexual assault, liable for these civil cases over and over again. When they're given the data, it is incumbent upon us, we the people, to make sure that Americans get the data, that just like the jury gets admissible evidence, that we are making sure that the American people are armed with the data.
Welcome back. Find out what 40 million people a month already know, that Legal AF is the home of law and politics commentary and analysis in the YouTube world. On Wednesdays and Saturdays, we do a long-form podcast called Legal AF. I do it on Wednesdays with Karen Friedman Agnifilo, on Saturdays with Ben Meiselas, and then on hot takes like this about every hour. We curate the top 3 or 4 stories at the crossroads of law and politics, and we bring it to you just like that with our commentary and analysis as practicing lawyers in the courtrooms that we talk about. We don't blow smoke. We don't blow sunshine. There's no censorship. Nobody tells us or me what to say, and we're completely unfiltered, unplugged. No outside investors. Nobody tells this network how to run its content. Nobody. We're just doing it for our audience. And if you're already part of our audience, I thank you from the bottom of our heart. We couldn't have gotten to 3 million on the MeidasTouch network without you. If you haven't yet found Legal AF as part of the content that you enjoy on YouTube or on podcast, I, Michael Popok, personally invite you to join us Wednesdays and Saturdays at 8 p.m. Eastern Time at 8 p.m., where you can watch a live recording or participate and chat with the anchors. Or you can pick it up the old-fashioned way, the OG way, the way I do, on audio podcast platforms of your choice. Just tap in Legal AF. So until my next hot take, until my next Legal AF, this is Michael Popok reporting. Heary, heary, Legal AF Law Breakdown is now in session. Go beyond the headlines and get a deep dive into the important legal concepts you need to know and we discuss every day on Legal AF. Exclusive content you won't find anywhere else, all for the price of a couple of cups of coffee. Join us at patreon.com/legalaf. That's patreon.com/legalaf.